I said, hey, yo, good evening, everybody. I told you I was going to have more of an update on the female that set my brother up. Here is her first court appearance, and I will let you guys listen in on what was said.
She's here on a one-count defamation charge of accessory after the fact, which is a maximum 7-year felony, docket number 22CR10084. I've had an opportunity to speak with her, and I'm prepared to go forward, Your Honor. I would waive further reading, waive the 24-hour rule, ask the court to enter not guilty plea, demand discovery during trial. State did not indicate conditions of release, and although I did make a suggestion of bond, so let me see what they're arguing for, Judge, and then if I may respond at least once, we can see where we're at. Thank you.
Thank you. Turn back to Court for reading this charge. Your Honor, the state is requesting conditions 1, 2, 10, 18, condition 6, Jackson County. Condition 2, Slave Russell, and the condition 11, which we with exceptions for question and jury instructions, we are asking the state to place the status defendant has 5 open criminal dockets on matters that are the most serious offense. Under charges of housing, he also has 3 pending charges.
So, meaning she had 5 open cases already. She already had 5 open cases. It was like domestic dispute, child endangerment. Well, he's gonna name it. Let me continue.
Charged for criminal threatening as well as violating conditions of release. As detailed in the affidavit above, has the state of New York and discharged release, given those times as well as the increased stress or collective prosecutions given newer charges. As well as criminal convictions actually charges New York for issues with respect to prosecution. We ask the court to continue to reach $2,000 out.
50.
Thank you. Mr. Magnet?
Thank you, Judge. The records check supplied to me by the court from what was put in Odyssey by the state indicates 2 open dockets with 1, 2, 3, 4 charges, domestic assault, cruelty to a child, and a contempt. Those 2 matters involve an ongoing custody dispute between the father of the children, who is not Mr. Russell, Mr. Manoia, his girlfriend Nina Cuse, and my client, Your Honor. One of those has been pending since about the middle of the pandemic of 2019. And still has not reached trial. We don't represent in those matters, Your Honor. I'm just generally aware of them. Her records check, even though she has these pending matters, does not indicate a violation of probation, does not indicate a conviction for contempt, although that is one of the charges in one of the pending dockets, and doesn't indicate any failures to appear.
So basically, they were trying to see how deep her charges were and whether they were going to allow this charge to stick or whatever the case is. So the charge did stick, and as of November 20th, I want to say, she is supposed to have been also incarcerated. But however, they let her go. Let her go due to her agreeing to keep a contract with the courts, which was in agreement because, as you can see, it was like, why let her go? Basically, just why let her go? It didn't make any sense. Well, let's continue to watch.
Here, Your Honor. She's born in Bennington, although she was raised in Hoosick Falls. As from your time down here, you know that is a border town with us, right across the border. All her immediate family, father, mother, brothers, sisters, all live over in that area. But by client has two sets of children that she visits in Bennington, where she lives, from Bennington parents. One is the tumultuous or the prior problematic relationship with Mr. Manoia and Miss Hughes, his new paramour. And the other one is Mr. Wilson, although she is married to Mr. Wilson, they've been separated for some time. And those are structured visitations that she has over there. Two of the children visited home for a matter of hours, and two of the children are supervised visitation out of the home. So she has strong ties to our community, even though she was born here but raised in the border town, Your Honor. There is nothing in this case that indicates flight, Your Honor. They look for her on the 28th, they issue an arrest warrant for her on the 28th, and they arrest her on the 28th, sitting outside her house where she lives. If they'd given her a call, she probably would have come down, because she'd already come down and given a statement in the, I guess in the tangentially related matter involving Mr. Russell. And although the allegation is that statement amounted to accessory after the fact in some form, it did not indicate flight or failure to appear. There's nothing to indicate that a curfew here would indicate her presence, Your Honor. What I would suggest would be appropriate would be 1, 2. I have no objection because of the nature of the underlying proceedings until they're understood better. 14. As to Mr. Russell, there's nothing there that indicates that she would harass him. But if the state, for the integrity of Mr. Russell's case, doesn't want contact, I don't have an objection to a 14 at this point in time. So I would suggest 1, 2, and 14 as to Mr. Russell. I don't believe a cash bail, which, as the Supreme Court has indicated, is needed for the purposes of procuring presence, suggests a least restrictive number of conditions to procure presence on this records check, Your Honor. The only stake that I think that the court bears a little bit of consideration is she now has several matters, Your Honor. These are still not matters beyond the pale. In other words, such that jail time would be mandated by any reasonable person. That's still probably an ongoing situation. And this matter does not involve the subject of those two cases. So with all that...
Now, if y'all saw what I just did just there, I think I fucked up when I did that, especially on camera. You know what I'm saying? Like, at the meeting, because it was like right after I did that, the judge does some fuck shit. So pay attention.
All that said, Your Honor, I would ask the court to impose 1, 2,
mind you, this is an ongoing case.
Russell as to this new felony matter.
Murder case.
Mr. Burke? Yes, Your Honor. We do believe that the defendant continues to present a risk of flight from prosecution. While this charge on its face would not necessarily be a jail charge, it is an accessory after the fact to a murder, and the state will be seeking significant jail time as a result of the defendant's actions in assisting Mr. Russell from avoiding prosecution.
Right.
Given her out-of-state ties as well as thematic charges and the significant risk that she does, the significant risk that jail will be imposed in this type of case, which does present a risk of flight from prosecution, and we do ask the court continue the bail.
So, Judge, I assume the court's read the affidavit. You know, the amount of assistance that she could have given Mr. Russell here is minimal, quite frankly. The allegation of homicide.
Yeah, I'm in court right now.
The decedent makes
I'm in court. So I'm gonna stop the video right there because my sister tended to call me, and the video was kind of, you know, really you couldn't barely hear. So basically, long story short, they let the bitch go. I was mad as fuck. You know, I think I started crying or whatever the case is. I don't even know and stuff. But they basically let her go. My brother's wife spoke right there. She was there. She had spoke. And was saying, you know, they shouldn't let her go. But then they did. You know, it was like, really? y'all was gonna let her go anyway. But stay tuned for a more update, because in recent events, like I said, November 20th, as of November 20th, she has been charged with accessory to murder. So please stay tuned. And I appreciate you guys for watching with me and staying updated on Ulysses Diamond Ivy Jr. case. Stay blessed.